Non-disclosure agreements, or NDAs, help ensure businesses can give employees access to information they need to do their jobs, without allowing them to later use that valuable information to the business's detriment. But creating a valid NDA and enforcing it pose tricky questions for both employers and employees. We're eForms, the world's largest online database of fillable legal forms, and in this video we'll cover the way NDAs are usually enforced, the standards and issues that go into enforcing them, and common issues to be aware of. NDAs implicate many tough questions, and it's possible that an improperly drafted one will not be enforced. For a non-disclosure agreement that meets essential requirements and can be customized to fit your situation, click the link that appears at the end of this video. First, let's establish how NDAs are typically enforced. A non-disclosure agreement is often contained in employment contracts and are intended to prevent the release of sensitive information. They work by discouraging people from violating the agreement in the first place. NDAs are contracts, and if an NDA is valid, the party that breaches the contract can be sued by the other and forced to pay damages. For disclosure of trade secrets, there are specific federal laws allowing for the collection of damages well beyond what the breaching party caused. If one party breaches the agreement, it's typically a good idea for the other party to send a cease and desist letter demanding that the release of information stop. This can both protect further release of information and help legal claims, because the non-breaching party usually has an obligation to mitigate damages. In many cases, parties want to stop the release of information before it happens, because once released, the information is difficult to contain. If one party has reason to believe that another is about to disclose information and that doing so would cause harm, it's possible to go before a judge and seek a court order to prevent someone from disclosing it. This is called an injunction, and unlike a request for damages from a contract, a violation could lead to jail time. Injunctions, however, face different standards and can be difficult to obtain, particularly in matters involving speech. Now that you understand how NDAs are enforced, let's step back and take a look at the issues that might make one unenforceable. Because NDAs are contracts and face the same types of requirements, an NDA that is signed under duress, for example, will not be enforceable, nor will one that was signed through deception or by mistake. But because NDAs also have some specific concerns, some NDAs, for example, might raise First Amendment concerns because they touch on information that is of significant public importance. In this case, a judge may weigh the interest protected by enforcement against the free speech concerns. Another issue concerns non-disparagement agreements, a type of NDA that protects people from revealing injurious but true information in the future. Because these agreements have been associated with enabling workplace harassment, states like California now significantly restrict their use. In general, NDAs in the employment context are enforceable only to the extent that they are necessary to protect the employer's business. Here are some common problems where NDAs are afoul of this. Scope of coverage. A non-disclosure agreement that is too broad won't be enforced. In general, NDAs can't cover information that an employee learned independently of the job. Time period. There should be some relation between the amount of time the NDA lasts and the sensitivity of the information. It makes little sense, for example, for information that will become obsolete or outdated in 3 years to be protected by an NDA lasting 10 years. Penalties. A non-disclosure agreement will often contain a clause that sets out what the fine will be for violating the agreement. This is known as a liquidated damages provision. Liquidated damage clauses can be enforced, but there must be some relationship to the damages caused by disclosure. Sometimes there will be terms asked to the employee to acknowledge that the fine is reasonable, but even if there is, a provision that is excessively high will probably be viewed as a penalty and won't be enforced. Assessing the validity of a non-disclosure agreement is an essential skill for both employers and employees. Be sure to watch our previous video about the basics of NDAs, and don't forget to subscribe for more videos about important legal topics.